Welcome to PitchMark. I'm Mark Laudi with our legal advisor, Frank Rittman in Bangkok. Hi, Frank.
Hi, Mark.
And today we're going to be looking at a celebrated case in Luxembourg where a US-based Singaporean photographer has won her appeal against a plagiarist, somebody who took her photo, created a painting, and now finally we've seen the final word from the courts. On appeal, Jingna Zhang has won her case over this photograph that we're showing here, which in essence tells us that the defendant, in this case, Jeff Dishberg, was not entitled to use this likeness. So we're speaking to the legal counsel in this case. He is Vincent Wellens at Nauta Dutil in Luxembourg. Congratulations on winning the case, Vincent, and tell us firstly what the latest status is.
So thank you, Mark. Yeah, you correctly stated. So we have an appeal decision, which is in principle the final decision. Could be a Supreme Court appeal, but that's only on points of purely legal points and not on factual assessment. So it's quite unlikely that there will be a Supreme Court appeal, but you never know. So basically, in principle, this is the end of the journey. So yeah.
And obviously, it's been a very long journey. How many years has this case been prosecuted, and what is the final outcome?
Yeah, it has taken 2 years. There have been some procedural delays. Also, I think the dockets of the Court of Appeal were quite full, so that they just at some point of time didn't find the date. So at some point it was shifted up for 7 months. But yeah, so it's also a first instance and an appeal, so it takes some time. In first instance, we lost the case, but now we reversed the first instance judgment, and yeah, we're quite happy about it. Yeah.
And so the painter, Jeff Dishberg, the defendant, didn't now, or is no longer permitted to use the painting. Is there any other penalty?
So there are 3 things. So he cannot expose the painting anymore, and he cannot sell it on, and he has to pay a procedural indemnity of €3,000 to my client.
All right. Now, Frank, when you first spoke to Vincent 2 years ago, obviously we're interested in this because at PitchMark we're always looking to defend IP rights. We're looking to deter IP theft. Frank, you've also followed this for the last 2 years.
Yeah, Vincent, I want to start by congratulating you on your perseverance. I was just curious, out of thin air, out of left field rather, how many hours do you think you spent working on this case over the past 2 years?
It's a good question. I should dig it up a bit, but I think it's really a lot. So
more than 100.
It's really 1 in 100, and there has been also some, because the case was quite mediatized in Luxembourg, but also outside. So there has been also some work of, responding to media requests, etc. I think. Jingna, when she came to Luxembourg, there was also a filming crew with her, so they ran a kind of documentary. Yeah, so it was quite. It took a lot of non-lawyer time as well. So, but yeah.
Well, I want to return to that in a minute, but I recall when we spoke. So far, we haven't been able to see a published decision. Is one available yet?
There will be one within this and a week. But if judgments are published in Luxembourg, it's in anonymized version. So, you will not see the names, but yeah, if you know who the both parties were, you just have to. For example, Jingna will be replaced by person A, and Jeff Dishberg by person B. But yeah, and then it goes through the whole judgment like this. So
well, we saw your client's comments, but that was really about it. And so to Mark's point, it wasn't really clear to us, was there a further line of appeal, and what exactly in substance was determined? Was it in fact determined that there was an infringement?
Yeah, in the end of the day, so there was copyright infringement. So the other party from the beginning, they contested nearly every point. So it went quite far. So they went that far by saying that Jingna was not the author if there was copyright protection at all, because obviously you're on a photo set, and it's also kind of collaborative work.
The
There are a lot of
hairdresser, the
people
makeup
running
artist,
around
model,
on a set. I think, Mark, you also are not alone now. I think we have a lot of technical people running on the set. So on that point, the first instance judgment followed us that Jingna is the author, the sole author of the picture. And then it went down, is the picture sufficiently original to enjoy copyright protection? Originality is the condition to have copyright protection at all. And there the judgment was a bit short by saying, yeah, that we didn't produce sufficient evidence on the originality, although we have set out on which points of the picture Jingna took decisions. We had also some attestations of the magazine, of a person working on the set, and the judge didn't take it really into account. And it seems that the judge was rather led by the fact that, you know, the picture, you see it, Frank, in front of you. It's quite a classical pose, you know, of the, it's quite a classical pose, and that was for the judge actually the main finding, to say actually the picture is not original enough because it depicts a classical posure. But that is not relevant in EU copyright. You even can have EU copyright on portrait photos. You know, portrait photos is the most banal, the most common pose that you can have to take a picture. It's a portrait photo, right? So, and the Court of Justice of the European Union has said clearly in relation to that it can enjoy copyright protection. But first instance judgment didn't follow that line, and then we said, okay, the bar is quite high for copyright protection in Luxembourg, and if you put the bar higher, we will jump higher, and that's what we have done in front of the Court of Appeal. So we have explained in even more further detail what creative choices Jingna has made to make the picture what it is in terms of pre-production, production, and post-production.
When we spoke a couple of years ago, it almost seemed that they had presumed that there was in fact a copyright. You had anticipated they were going to say there was a transformative use that isn't defined in the Luxembourg law, and that this may have been some form of a parody, which we also discussed wasn't really yet defined under Luxembourg law. And then, yes, you made the point of it being a collective effort, and that, you know, there's the hairdresser, there's the makeup artist, there's the model.
Yeah.
And I think the defense counsel even disparaged your client by saying all she really did was press the button on the camera. He could do that. Understanding. But was that all just a lot of talk in the press at the end of the day? As you say, the court seemed to go off and ignore all those arguments altogether and made its trial decision on a different basis.
Yeah. So as explained on the collective effort, there was a real distinction made by, in first instance and before appeal, that it was recognized that these people were all people who have a technical role on the set, and that it's Jingna who was actually directing and the person in charge. But then on the originality, there in first instance the court followed the reasoning of Dijkburg, and also on just clicking to have a picture. That was actually one of Dijkburg's counsel one-liners. There we went also into detail by having the metadata of the photo, by saying that, you know, it was not automatic. So all the light, etc., it was really made by Jingna, who really decided on each parameter of the photo how it should be, and that some choices were also unusual in this respect, you know, so that you choose the brightness of the light, and that you set some parameters in your device, that it's not just automatic, because these modern devices, can do it also automatically now,
It
and that
just
was
seems,
also a point that was.
it just seems incredible that you would have to go to this level of trouble in a court of law
Yeah,
to
absolutely.
establish this level of factual element. When, as you say, this was a photograph that was published on the cover of Vogue magazine.
Yeah.
Um,
It's incredible. So that's but that's a very good point that you touch upon, Frank, because we made it, because the bar was very high, and we were able to jump very high because we were able to have the necessary statements, to have the metadata. But imagine that you are, a professional photographer, and you do not document well all these things. Then it could very well be that you just don't make the cut to get that protection.
Not only does it sound like a high bar, but also very cumbersome procedurally. I've supervised some litigation before, and going to that level of trouble to introduce that level of evidence into court, I'm really shocked that the court costs over 2 years only amounted to, if I'm not mistaken, $1,600 US.
Yeah, so that's a procedural indemnity.
I mean, that sounds like a lot more expensive to go through than that.
Yeah.
I think litigants around the world envy at the cost of $1,600 for 2 years worth of copyright litigation. Unheard of. But it just seems like you spent a lot of time and effort going to establish these very, very basic points that you wouldn't thought you would have had to go through in the first place.
Yeah, it has become also a reference case, in the sense that the other party made a reference case out of it. So, and I think now we have a kind of seminal case, and everybody is really as I said, it was mediatized. That's maybe one thing that I forgot to mention. We also asked for a publication measure of the judgment into Luxembourg journals. And that request was dismissed because there was already a sufficient enough buzz around the case, according to the judge, and that's fair enough. He didn't grant the publication measure, but I think Jingna, she put the statement on Twitter, and I think it has 10 million views. So that can count in terms of publication. It can count.
It certainly resonated in this part of the world. You raise an interesting point, though, because not only were her intellectual property rights infringed, she really also underwent a lot of abuse online. I know that there were a lot of unfair comments and attacks, and her personal address was given out, and people really lined up against her. Did it ever occur to her to include any request for damages, either to her reputation or to
well, we, of course, you can imagine that we have maybe some suspicion from which corner some of those came, but obviously we are not sure. Those people have not been identified, but it is certainly maybe at this stage. That has to be also discussed with Jingna, but that it would always be possible to file a criminal complaint for this for all these things that happened actually in the margin of the case. We did not want to file a criminal complaint before because we wanted to keep the copyright case clean without all these other side elements, etc. First, to secure that win, and then see if and when we would maybe act on a criminal level, because in any event you would need the support of law enforcement to see who is behind some of those comments. It's not something that we can identify. So.
And another thing, in Asia, it's fairly commonplace in these sorts of situations to demand and obtain an apology as well. Is that relevant in Luxembourg?
No, because first of all, it's not common, and secondly, it's an injunction. So it means that you only can ask things not to do anymore, and you cannot ask to do something positively, with exception to the publication measure. But for the rest, you cannot
You can't get an apology for past infringements, for prior infringements. You can't, you know,
No,
I'm sorry I infringed
no,
your rights. Wow.
no.
Okay, that's a point of departure. I'm curious, you know, you mentioned before there might have been some organized efforts behind it. You guys really were reasonable at the beginning of this. I remember for months before you filed the complaint, you said, look, really, we really just want to start a dialogue. These sorts of things happen. As I say, the painter seemed to say at the beginning, yeah, I got inspiration from her painting. I get inspiration from everywhere. That's what we do in artists. And then it just got really personal and nasty. And I'm just curious, why do you think it got so much vitriol got introduced? And it just became, you know, a real push-up match. Why did it get so nasty and aggressive?
Yeah, it's maybe probably because of the choice of the lawyer. The lawyer is known to be, I think, he's a very good criminal lawyer in the end. So he does a lot of personalized case, but he's known to be quite. I don't know. I have to weigh my words in English, but really a more well. Let's put it that way. A highly assertive lawyer who is not afraid of blowing up things in the press, and that's what he did. It's probably one of the points of the tactics, and then obviously if you do that and there is no point of return, then you have to go for that infringement. Yeah. So.
Yeah. And you wonder whether you're doing your client a good service at the end of the day. You're right. I think this is in many respects a career-defining case for all sides. At the end of the day, though, I mean, I don't mean to sound insulting. I'm not sure that there was anything terribly remarkable about it. This all seemed very straightforward. The act of infringement. I mean, what are the main takeaways that you see out of the case?
Well, as I mentioned before, so it's a nice win. It resonates. People think now, okay, it's easy to get copyright protection for pictures in Luxembourg, but in the end of the day, if you really read, well, obviously it hasn't gone public yet, but if you read the case, it's yeah, in my opinion, the bar to prove originality is still quite high. And again, the photographers like Jingna who do fashion photos where you really can see the effort and also I think in the sector things should be better documented. Also the relations between the different people who are on the set, it's not always very well contractually defined. So you should have the contracts better in order. And also document the creative process. It may be burdensome for a photographer, but in the end of the day, it can save his IP rights or her IP rights. So that are the main takeaways. Because I'm afraid that in the category just not below, but for other types of photography, I don't know, like people, press photographers, etc. They may have it more difficult to enjoy copyright protection for their works.
Should. Well, thanks for that, Vincent. I mean, congratulations once again to you and your client for your perseverance.
Thank you.
You know, this is really, at the end of the day, it's a nice story.
Yeah. Well, you know, to some extent, Frank, your question is well justified. You know, what did you get out of it? Because, you know, Vincent, thousands of creatives will be watching our video and they'll be saying, man, if I have to drag myself through 2 years of litigation in a court and then there's not even any damages payouts at the end of it, gosh, is it all really worth it? Well, what's your message to them?
I think it's worth it because it still has a deterrent effect. I think this case, okay, we didn't obtain damages because most probably the damages would be very hard to quantify, right? So it has been, the painting has been exposed for maybe 3 days in a rather small country. So that's, I don't know whether you get that much damages out of it, but it's a deterrent effect, you know, that copyrights can be protected and are worth to be protected. And I think some other person will probably think twice before copying pictures of Jingna or someone else. So it has certainly a deterrent effect, and I think it comes a bit also on the right time, because now with artificial intelligence, skimming pictures from the net and using all of these, I think it could be good to remind actually that that pictures that are used could enjoy copyright protection, and it could be problematic.
Well, at PitchMark, we have actually quite a number of our members who are using PitchMark generated photos, right? So they're looking to defend their IP rights when it comes to images that they used some sort of AI platform to create. The metadata that you mentioned earlier, like capturing the creative process, who's involved, who's contributing to the photo or whatever other creative work that you're looking to PitchMark, becomes much harder when actually all you're doing is keying some words into an AI platform, isn't it?
Yeah, that's true, yeah.
So would it be fair to say that if you have generated something using an AI platform, then it'll be much harder to defend your IP rights over that than something where you yourself picked up the camera?
Absolutely, because but it depends on the jurisdiction, right? So maybe some jurisdictions are more open about it, but in the EU, copyright is still linked to a person. I think the definition of originality is actually that you have a kind of imprint of the personal character of the author. And obviously, if you have an AI generated element, yeah, you cannot link it to the person. So yeah,
Well,
it's
Frank,
certainly true
like,
that copyright in the EU is not up for the digital age and even less for the AI age.
Well, I think, Frank, we could probably say the same thing about us here in Asia, right? I mean, $1,600, I don't know whether you could be able to prosecute a case in a court in Asia for that price. In fact, you probably pay that much just for parking at the courthouse, let alone any litigation inside of it. Any thoughts, final thoughts, Frank, on this case?
No, thanks very much for the very comprehensive details and discussion. As I say, there's not a lot available out in the public at the moment, so we're quite curious to read more as it comes out. Thanks so much for the meantime.
Thank you very much.
Thank you very much. Vincent Wellens joining us from Luxembourg. And ultimately, Frank, I guess that does also show that deterrence and prevention is better than the cure.
Matter of principle as well.
Yeah. All right, thanks for watching. And leave your comments next to this video. And of course, we look forward to seeing you next time here at PitchMark. Mark Laudi and Frank Rittman signing off. Bye for now.